Viewers, Namaskar. This is possibly the last video we are doing for the year 2025. We'll be seeing you again in 2026. What I would like to say is that I check almost all the judgments coming out from NCLAT. Even with Supreme Court, I check all the judgments, not only the ones which pertain to Insolvency Bankruptcy Code, also I look into other judgments if a segment could be applied to Insolvency Bankruptcy Code, and then select, and then thereafter, even with respect to High Court judgments also, the judgments which come out on IBBI web portal, I mentioned those are also uploaded in guide2ibc.com. Now, for the sake of making this video, we select a few out of these judgments. So you can say these are double-toned case laws which we present to you. Why? Because one, toning is done by, we don't take all the judgments, we do a selection, and then even with Supreme Court also, and then out of that we select some and present only a few for you. While for health, for metabolism, double toned milk may be good for health, but for judgment, for knowledge, knowledge and metabolism are not the same. So I would strongly recommend that though we are making this video and presenting it to you, you should look at IBBI website as well as guide2ibc.com. See the cases which are coming on daily basis, which will help you in gaining knowledge and more interest on the subject. With this, I take you over to the presentation.
Friends, what you see on your screen is guide2ibc.com homepage. Now, what I would like you to pay extra attention is that you look at what's new on the displayed on the front page of the homepage of the website. What's new actually shows last updated 13 cases. And if you click on any one of them, it will show you the section or regulation it pertains to, or in which section and regulation it has been segregated, and the topic concerned. This will help you in any law. Like any law, IBC is also going through evolution, constant evolution, and evolution is best displayed or understood through mood of the judiciary, through judgments. So this will be very helpful for you in understanding the flow of insolvency and bankruptcy code, and to be at par with the recent trend. Now, with this, we move to the main case. That's in section 3. Section 3, subsection 6 pertains to claim. Now we come to the topic 3. Our concerned case is Union Bank of India versus Mr. Kiran Shah Company Appeal, so and so. Now, in this particular case, what happened was Union Bank of India had granted loan to a corporate debtor. And the corporate debtor failed and it was admitted to CIRP. And then even corporate guarantor was also instituted to CIRP. Now, this claim was lodged by Union Bank in the case of corporate against the CIRP of corporate guarantor. Now, when the claim was lodged, the RP came to the conclusion, looked into the claim and rejected the claim based on since the guarantee had not been invoked. The matter went to NCLT, and NCLT agreed with the resolution RP that the claim had not been invoked, so there was no debt as such. The matter went to NCLAT, and NCLAT decided otherwise. Now, let me take you to the slide share. Please go through this case. It's interesting. Now, let me stop the screen share here and take you to the slide share. But what you see on your screen is the slide. Now, it will help you in recollecting a Supreme Court judgment, recent judgment rather, China Development Bank versus Doha Bank, QPSC and others. So in this case, the NCLAT was of the view that default of debt has nothing to do with the claim of the person, and the maturity of the claim or default of the claim, invocation of guarantee for claiming amount has no nexus with filing of claim. Now, these are two completely. Now, we know that what constitutes a claim. Now, when you are lodging a Section 7 or Section 9 petition, the default debt and default are mandatory to be established. But for the purposes of lodging a claim, the liability is enough. So even if a guarantee has not been invoked, it will, claimant can definitely file a claim. And this was decided by Supreme Court in China Development Bank. So the NCLT said that for submitting a claim by a financial creditor, there is no requirement of actual default. The claim based on guarantee deed is maintainable even if the guarantee has not been invoked. Thus, RP as well as the adjudicating authority appears to have committed a patent illegality in rejecting the claim of the applicant. So this has helped us to recollect what we read in China Development Bank. With this, we move on to the next case. We have come to the next part of the presentation. What you see on your screen is Section 5, subsection 20, which deals with who is an operational creditor. IBC defines an operational creditor as operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So with this, we move to the case. Now, this is the second matter, which is Jatinder Oberoi versus Narendra Singh Chabra, NCLAT case. This deals with a thing called Del Credier Commission. I remember when I had appeared for an interview, I wanted to be a professor, and I had appeared for an interview, and I was asked, I had already passed MCOM and also CA. I appeared for an interview, and I was asked, what is the Del Credier Commission? And I couldn't answer. So when I saw this case, I was elated that yes, Del Credier Commission. So in this, what happened is a Del Credier agent lodged a Section 9 petition against a corporate debtor. The corporate debtor went to the court and said that he has got no locus because he's an agent, as simple as that. So it will be interesting to go through this case. I'm not going into details. It's a Del Credier Commission agent is altogether a different subject. So I would like you to go through the case, and this will give you a new idea. New concept of what Del Credier Commission is. Now, with this, I stop the screen share and I take you to the slide. Now, the topic is when the CD has failed to pay the principal amount for certain goods, to the Del Credier Commission agent, such amount would qualify as an operational debt, and a CIRP application under Section 9 of the Code would be maintainable. Why? Now, we have to understand what is a Del Credier Commission agent. An agent is usually, the contract is usually between the buyer and the seller. So when the person is selling, he is the operational creditor. And when the buyer is buying, he is the corporate debtor. But in Del Credier Commission agent, the entire responsibility of collection shifts to the Del Credier Commission agent. If the buyer doesn't pay, it's the Del Credier Commission who has to pay to the operational creditor. That is the supplier. All cases, whatever the recovery norms, everything has to be handled by Del Credier Commission agents. So in such case, what happens is The Del Creditor Commission agent becomes the operational creditor because Section 520 says what? 520 says an operational creditor is defined to mean a person to whom operational debt is owed and includes a person to whom such debt has been legally assigned or transferred. Now, a Del Creditor Commission it means that the debt is transferred to him. So, if money has not been paid, Del Creditor Commission agent has got full right to institute a Section 9 petition against the defaulting corporate debtor. And obviously, the uh, order will be granted. Now, this is absolutely a new thing of in Section 9, and as well as this is not 521, this is 520. This is a subject of 520, not 521. So you will have to notice this. And this is an interesting case. I think you will find it very interesting. With this, we move to the next case. Friends, what you see on your screen is the desktop of guide to ibc.com pertaining to CIRP, regular CIRP sections and regulations. Let us come to section 40. And topic 6. Our case is Farhad Suri versus Dhiren Navalakha. This is a very recent Delhi High Court case. It's a very interesting case in which what happened was the company had issued a check to a party. The company had gone into CIRP sometime in 2019, and this check was dated 2020, March or April, September 2020. So this was during the moratorium period. The check was presented, and when presented, the bank said that they returned the check with a remark, account blocked. Consequent to the dishonor, the party lodged a complaint under Section 138 of Negotiable Instrument Act. Now, Delhi High Court went through the entire matter and said that no insolvency proceeding can be, no 138 proceeding can be instituted. Now, if you'll remember, in P. Mohan Raj versus Shah Brothers, the Supreme Court had said that if there is a check bounce, there is no vicarious liability as far as company is concerned. But pertaining to individuals, they are subject to vicarious liability under Negotiable Instrument Act. Now, this is a little bit different then. So let me stop the slide share here, screen share here, and take you to the slide. Now, the court held post-moratorium, the accused cannot be held vicariously responsible for dishonor. Why? As I said, that in P. Mohan Raj, it said that there is no liability of the company, but individuals are responsible. But the court here looked into the entire matter, said that the company was taken to insolvency in 15/4, the order dated by 15/4/2019. But whereas the impugned check are dated 7/9/2020. Now, it is not what is most important is that it is not a crime. It is not a crime to issue a check. To constitute an offense under Section 138 of NI Act, mere issuance of a check is not sufficient. Issuing a check is not a criminal incident. It becomes punishable only when the check is dishonored for the reason of insufficiency of fund. So here the check returned, obviously because of the reason account blocked, because the directors didn't have any control over the account. The company was in the control and custody of the IRP or the RP. So the check was obviously going to return. And when the person who had issued the check had no control over the account of the bank account, then it cannot be. And as I said, it is not, it doesn't constitute a crime to issue a check. It may have been a post-dated check. The crime happens if the check is returned with insufficiency of fund. And when the check was not returned because there was insufficient fund, it was returned with the remark account blocked. So when a check is returned because with the remark account blocked, how can a director be responsible? So this is a thing which is absolutely different from what you have read till now. And that is the reason this is a little different judgment. And that is the reason I have shared it with you. Is it, to say in Hindi, this judgment is a little hutcake. So I hope you will enjoy going through this particular case. So with this, we move on to the next case. Viewers, we can see the dashboard of IBC sections versus CIRP regulations again. Now let us come to section 24. Quick 9. This is a case of Kajal Aizaz Ilmi versus Ram Kumar, NCLAT matter. In this, the directors were not allowed. This was pertaining to the CIRP matter of JE, and wherein RBI had instituted Section 7 petition. And the directors wanted a copy of the resolution plan, which was denied. A matter went to even NCLT did not, RP did not allow, NCLT did not allow, and the directors took the matter up to NCLT. NCLT also looked into the same case, referred to earlier Supreme Court judgments, and said that no, but yet they stated that this cannot be allowed. Now we need to see why. Now, let me stop the screen share here. I would request you to go through the case here on the website. But to make things simpler and crisp, let me take you to stop the screen share here and take you to the slide. Now, the NCLT, the heading is RBI having superseded the board of directors and appointed an administrator for the company, for the financial service provider. The erstwhile directors cannot attend COC meetings and are not entitled to documents from the RP. Now, you will remember the Supreme Court case in the case of Vijay Kumar Jain versus Standard Chartered Bank. Supreme Court had categorically held that RP, that the erstwhile management has got every reason to attend COC meetings and also receive copies of documents, all documents. But whereas in this case, it is stated different. Why? Because in Section 7 matters, what happens is the case is instituted by RBI and already a criminal proceeding begins against the directors. Then they are superseded. The board is not suspended. Board is not there, non-existent. So directors are no more a party, no more. They lose control or they lose right to attend the COC meetings because they are no more directors. They are already superseded by RBI. And it is not RP who is handling the matter. It is an administrator who is handling the matter. So under such circumstances, the court held that the erstwhile directors are not entitled to get any documents from the RP. Well, when the resolution plan is accepted, it becomes a public document. So under Evidence Act 1872, they can see it then. But at the moment, When the CIRP is going on, it cannot be. So, eh, having deemed to have vacated their offices, because RBI has taken over, they have superseded the board of directors. So the directors, it is deemed to have vacated their offices on the supersession of the board of directors under RBI Act. And they could not have claimed any right to attend the meetings of COC or to participate in CIRB proceedings. The members of the board of the superseded board of, not suspended, superseded board of directors could not have made any claim to have a copy of the proposed resolution plan submitted by PRA during CIP proceedings. Because it deserves to be noted that RBI, having superseded the board of directors and appointed administrator, the appellants or the ex-directors had deemed to have vacated their office. So this is not a normal CIRP under Section 7. This is a Section 7 case which is instituted by RBI. And this is not a normal corporate debtor, this is a financial service provider, which is not deemed to be a corporate person if you look at Section 3. Because Section 3, I've forgotten the subsection, it does not. The definition, the items, the type of persons, entities who are considered as corporate person does not include financial service provider. So this is different. So we'll have to keep it in mind if we are handling cases with, or if you are a financial service provider. So with this, we march on to the next slide. We are now in the dashboard of corporate insolvency process, section pertaining to preferential, undervalued, fraudulent, extortionate trade, credit transactions and offences and penalties section. In this, we are coming to section 43. Case laws. Let us go to item 16. This is Sharp Business Systems through Finance Director versus Commissioner of Income Tax. Here we are not concerned with the entire case. It's a Supreme Court matter. We're just concerned with an end part of it, which is really, really interesting. It's a Supreme Court judgment in which it says that no businessman can be compelled to earn maximum profit. In this, what happened was Sharp Business, they had a subsidiary. They had, to its sister concern, it had borrowed money and given it to the subsidiary. And the subsidiary had invested the fund in taking control of minimizing competition in the market by taking over, buying shares of a competitor. The revenue stated that no, this was a preferential transaction, and the interest amount which is saved, the preference which is given has resulted in loss of the company. So they had taxed. Here the Supreme Court was of a different view. And this applies to Insolvency Bankruptcy Code, because we are supposed to see whether this is a preferential transaction or not. Yes, this is very much preferential transaction. But is it in true sense of the term? So this is a very interesting matter, because what we normally think is profit maximization, that whether even in 66(2), whether a director, there's a wrongful trading on the part of the director, or 43, whether a preferential transaction has taken place or not. So with this, I would request you to go through the excerpts on the website, but let me take you to the slide I have prepared for you. Now, the slide is right in front of you, which says that no businessman can be compelled to maximize his profits. Now, what is relevant? Supreme Court said that what is relevant was whether assessee had advanced such amount to its sister concern as a measure of commercial expediency. Once the nexus between the expenditure and the purpose of business is established, irrespective of whether it was for assessing itself, revenue cannot put itself in the armchair of the businessman, etc., of the board of director, and decide how much would be reasonable expenditure. Because the authorities must put themselves in the shoes of the assessee or the businessman and see how prudent the act was. You see, the profitability and prudency are two different aspects. So, whether a fund which is transferred to a sister concern, we have to see whether there was a commercial expedience and not from the point of view of whether it was advanced for the purpose of earning profit. If the directors now, we cannot then in such case amounts transferred to sister concerns will always cannot be treated as preferential transaction. No, the court said that if directors of a sister concern utilize the amount advanced to it by the assessee or by the corporate debtor for personal benefit, obviously it cannot be stated to have that commercial expediency cannot be established. But there may be 1,001 reasons for the purposes of it is obvious the company has deep interest in the sister company, and hence, if the company advances borrowed fund to a sister concern, the same is used for some business purpose. It is perfectly legal. And we cannot say that there was a preferential transaction. We cannot say that there was a wrongful trading. So this is again a Hatke judgment. This is different from what we normally deal with in the case of Section 43 or Section 66. And this is a very important thing which we should keep in mind. So with this, I take you over to the next slide. And let's see whether we have a little bit different judgment or not. We are in the segment adjudicating authority. We come to Section 61. In 61, let us go to topic 24. Yeah. Our case is Balakrishnan Baldava versus Agritech India Limited. This is a case now we know that in Glass Trust versus Baiju Ravindra, there was a sea of change pertaining to the sea of change came in pertaining to the determining locus of a person. Now, in this case, we know that shareholders normally have no locus with respect to CIP proceedings or liquidation proceedings whatsoever. But in this particular case, the appellant who had moved the case was a shareholder of both corporate debtor as well as financial creditor. And he had moved the case under Section 65. The adjudicating authority considered the matter. But since they had done, adjudicating authority had heard the case in detail and was also considering Section 65, the financial creditor took the matter too. And so matter went to NCLAT. NCLAT held that an appellant definitely had a locus because he had his argument was definitely heard. And Section 65, well, the reason why Section 65 is what? When a CIRP is instituted for purpose other than insolvency. And it has been instituted maliciously. So let me do in fact, if you want to see Section 65 also, I can take you to Section 65. Let me see. I think it is topic number 13. Yes. If CIRP is instituted for wrongful purpose, action under Section 65 must happen. This is same Balakrishnan Baldova versus Agritech. The case is here. So with this, we stop the screen share and I take you over to the slide. Now there are two headings. Section 61 of Insolvency Bankruptcy Code confers statutory right to any person who's aggrieved against the order of adjudicating authority. And 65 says what? If CIRP is instituted for wrongful purpose, action under 65 must happen. Now, in this case, the appellant, as I said, the appellant had moved to NCLT complaining about 65. And that he was a shareholder of both the CD and the FC. He saw something wrong happening there. And obviously, he had every reason to be aggrieved. So NCLAT held that going by Glastra's judgment, they held that he definitely had locus. Now, pertaining to 65, what they saw, that the financial creditor had advanced 65 crores. Now, both financial creditor and corporate debtor were related parties. Their boards were almost identical. So the financial creditor and the corporate debtor had the same management. They had financial creditor had granted loan of 65 to the corporate debtor. When the matter went to NCLT, when the Section 7 petition was moved, practically there was no resistance from the city. And it got admitted it was done in a very mechanical manner. It was well established that IBC law and that CIRP is a creditor control process. And in that process, the shareholders have no standing value. And their shareholding gets zero or negative. So this whole thing was engineered so that the controlling group could get rid of the public shareholders. So when the objective, that is the reason when they did not institute Section 10. They went for the misused and they went for Section 7. So the entire purpose was fraudulent. Because by moving Section 10, Section 7 was not there. So they moved Section 10, they moved Section 7, and gradually they wanted to wipe off the private shareholder, and then whatever would have happened. But definitely the purpose of instituting CIRP was not for insolvency. It was for malicious purpose of getting rid of private shareholders. So this was definitely not acceptable. And NCLAT held that definitely Section 65, there is a case in hand pertaining to Section 65. So with this, we take the next case.
Viewers, we have presented some interesting cases. We hope you like them. I will request you to please like this video, subscribe to our channel, and also visit our website. If possible, share it with your friends, relatives, colleagues. That will help us in expanding those who follow the website, and that will be expanding their knowledge base amongst everyone in the fraternity. So with this, we take you over to the next lot of cases.
Are back in referential, undervalued, fraudulent transaction, etc. Dashboard. Let us come to Section 66. And the recent topic 34. The case is between Rana Sarkar versus Bimal Agarwal and others. I'm not going to the headline because the headline will come automatically when I do show you the slide. So in this case, what happened was the RP found that there were huge amount of cash withdrawal. In fact, tabulated also, it was about 1054 lakhs. That's still 10 crore 54 lakhs cash withdrawal in a span of 5 years. There were multiple related party transactions. There was a forensic auditor transaction audit in which the transaction auditor gave opportunity to the corporate to the erstwhile management. They replied that cash withdrawals were basically for paying laborers their food and others. And with regard to related party, they did not say anything. Nothing much. They said that these were all related to day-to-day going business purpose, which the NCLT did not accept. So the matter went to NCLAT, and NCLAT looked into the matter. I would request you to go through the case details. It's interesting. But if I want to go into depth into this video will go on for another 1 hour or so. So let me take you to the slide. Now, this topic is very interesting. When a Section 66 is moved, the initial burden regarding establishing the transaction as fraudulent is on the RP. But the RP cannot be compelled to tender that evidence which is impossible for him to file. Because you will understand that the RP is a temporary visitor to the entire process for the corporate debtor. He comes in for a period of 6 months. So though he has the responsibility to point out or to form an opinion pertaining to transactions which are fraudulent, he considers to be fraudulent. But he cannot be compelled to tender evidences which are impossible for him to find out or to file. Now, in this particular case, the auditor and the learned tribunal has not found explanations. They say that 10.54 crores were spent on wages, food, on to pay respective labors for the ongoing work, for site expenses, and for food and mess bills, etc. The auditor, the RP learned tribunal has not found this explanation as justified in the absence of any documentary evidence. There was no document. Just to say that, yes, we spent this money. Or maybe a sheet of paper. That's not evidence. Then there were many related party transactions. The ample opportunity was given by the transaction auditor to the corporate, to the erstwhile management to explain, and they did not. So the initial burden, so RP presented, and he had full right, and circumstantial evidence is definitely because NCLT is a summary court. So they ought to have considered that this was a fraudulent transaction and hold the directors responsible under Section 66, subsection 2. Section 66, you will remember the Section 66 has got two parts, 66.1 and 66.2. So 66.2 pertains to directors who are or the erstwhile management who could have reduced the loss. So the vague reply given by appellant to justify the transaction to have been done in ordinary course of business is not sufficient to justify the transactions were made when the company was admittedly in financial distress. So this is a very interesting case, and this happens. You see, a company goes into distress, and when the red light switches on, the siphoning of funds takes place. And it's for the RP to find out whether such siphoning of funds will be there. In 90% cases, this is seen. So, this is an interesting thing. I would request you to go through the case. With this, we march on to the Next case. Viewers, I told you that the next case, we would be in section 66. So I did not go into the dashboard. I'm still in the dashboard of topics pertaining to section 66. Now, this is the absolutely latest topic. And the cases of Mr. Kishore K. Avarsekar and another versus Alok Saxena. This is an enclave case. Now, in this, what happened was there was another one company called Magnum, through which the transaction auditor found that about money to the extent of 1,946 crores had gone round and round in circles. And out of that, there was one company called Magnum, through which back and forth through LC, everything was done through LC. 1,643 crores went in, came back, and things like that. An actual purchase from Magnum was only for 6.52 crores. So this is something this court mentioned that routing funds through intermediary, this is round tripping. In Hindi, इसको बोला जाता है पैसा घुमाना. Now, why is round tripping done? To save taxes, to evade taxes, to evade that definitely definitely not for very honest purposes, to be very, or for commercial sense. This is done for other purposes, and the NCLT had imposed a fine of 231.64 crores on the S12 management, and they went to NCLAT. So round tripping is something, this is a new term, I never heard of it. पैसा घुमाना तो सुना था, but round tripping is something new to me. I know about what is पैसा घुमाना, but round tripping as a term is new. So good. So it's quite a lengthy case. I would rather request you to go through it, but to make things easier to understand for you in this particular presentation, let me take you to the slide. Courts say that there is no presumption that merely because a letter of credit is issued by a bank, the transaction can never be fraudulent. There's a common belief, LC hai bhai. So there cannot be anything fraudulent in this. This is absolutely a myth. And court made it very clear here. The forensic auditor flagged certain transactions carried out with the entity's interested parties and an amount of 1,946.15 crores being fraudulent transactions. As I told you, with Magnum, 1,643.33 crores had been routed, and the actual outflow and actual purchase transaction was only 6.52 crores. So this was termed as round tripping. The document reflects that only purchase transaction of 6.52 crores against a huge amount of outflow to Magnum to the extent of 1643.33 crores, which is nothing except round tripping. The appellant, who were managing directors of the corporator, failed to protect the interest of the stakeholders, and thereby the ingredients of Section 66 of the Code are fulfilled. 66.2. Thus, there is no error in the impugned judgment. On this ground, whereby adjudicating authority had asked the appellant to refund 231.64 crores in all 8 transactions, sample transactions of LC. They found that same truck numbers were issued. There was no document, goods had moved. Even truck numbers used one truck number was used multiple times. in a day. Even truck numbers were not found in e-Vahan portal. So these were all bogus transactions. So paisa ghum raha tha idhar. Since there was no genuine purchase in all these transport documents, they were all prima facie fraudulent in nature, and a fraudulent transaction can therefore be carried out by a valid letter of credit issued by a bank. So the presumption that just because there is a letter of credit, there is holy water of Ganges sprinkled on the transaction is not acceptable. A fraudulent transaction can very well take place even if there is a letter of credit. So this is again a new thing we are hearing. So with this, I would rather request you to go through this case. These are all very interesting cases happening. So I would rather request you to go through the case in depth, and which will help you gain knowledge. So with this, we move on to the next topic. Viewers, we have dealt till now with Section 5, Section 3, CIP Section 16, CIP Section 24, 61, 66. How can we not come to liquidation? So let us take up a matter, an interesting case of Supreme Court, and move on to Regulation 33. Topic 18. I'm not discussing the topic now. I'll discuss the topic when the slide I prepared for you is discussed. Now, this is a case of Messrs. Sri Krishna Alloys Private Limited versus Ramakrishnan Sadasivan. This is a Supreme Court judgment, very recent judgment, to be honest. In this case, you can see that what happened was a company, they tried to sell, there were two land parcels or two asset segments, two asset portions, landed asset and factory shares and things. One could be sold and the other was not selling. 15 times, 10 or 14 times that auction had taken place. And ultimately the decision was made by shareholders, by stakeholders to sell it as scrap. At that time, a party came and said that I want to buy the asset. And they wanted to sell, the stakeholders had decided to sell it at 50 crores or something. So the stakeholders had suggested that they wanted to sell it at 50 crores. And this party came and almost paid the double price of or something like that. I mean, less price. They offered more double price and they gave 10% or 15% as advance and said the remaining money will be paid within 15 days. The 15 days never came. The the success the successful purchaser went to the NCLT and stated that give me more time. NCLT gave it some time, but stated that look, whatever you have paid, the entire money will be forfeited if you don't pay it. Right? But yet then also the money was not paid. So with the authority of the NCLT, the money was forfeited and the liquidator auctioned the property and sold it at 104 crore. The auction purchaser went to initially NCLT, then NCLAT, and ultimately the matter went up to Supreme Court. I would rather suggest that you go through the judgment. I've given it to you in nutshell. It's quite a interesting judgment. So let me stop the slide share here and take you to the screen share here and take you to the slide I have prepared for you. Is that time is a crucial facet of the scheme under IBC. But to allow such proceedings to prolong and cause indefinite delay would plainly defeat the very objective of the statute. If the case is moving on and on, back and forth, and this goes on, then the very purpose, IBC is both CIRP and liquidation are time-bound proceedings. So being entangled in litigations and dragging of the matter for time infinitum is not acceptable. So the Supreme Court held that contrary to its own commitment, in the offer made on 9/9/2021, appellant then sought extension of time beyond the stipulated 15 days. The appellant itself had asked for extension till 31/5/22. NCLT had every right to assume that since the party has asked for time till 31/5/22, party would arrange for funds. So on 29/6, it gave an order mentioning that if you don't pay by 30th of June, which was one day thereafter, then your entire money which you have paid will be forfeited. There was nothing wrong in it because the party should have had that money by 31/5 and this was 36. So 1 month had gone by. So he had no right. As appellant had approached the NCLT for extension of time by 2 months earlier, the NCLT would have obviously expected that the appellant would have arranged for the funds to be paid in terms of extended timeline paid for. So there was nothing wrong in NCLT having done this. And the sale and the appeal was disallowed. Appeal was not. I mean, the auction the purchaser was denied, and the asset was allowed to be sold to the new party through auction, and the company thereby gained. So this is a new thing. This is not a new thing. We keep on seeing this every case, but this was a very assertive judgment on the part of Supreme Court, and we should keep it in mind. So with this, we now move on to personal insolvency. So that is insolvency of personal characters. We are back to personal characters. Personal characters, but we are in the individual and bankruptcy proceedings. We are dealing with Section 94. Section 94, let us go to topic 9. This is a case of Manish Mahendra Somani versus Bank of Baroda and others. In this, what happened was an order under Section 94 was given. The court had appointed an RP and had advised the personal guarantor to inform the RP to give a report under Section 99. The personal guarantor conveniently forgot about it, did not send any notice. 15 months went by. And when the matter came up again, it was taken up by adjudicating authority. It was seen that RP had not filed 99 notice. So the adjudicating authority cancelled the entire Section 94. So the personal guarantor went to NCLAT stating that what is this? RP has not given the reply, report under 99. For that, why have you cancelled my 94? So NCLAT looked into the this is a new thing. So let me take you to the slide. The court was of the view that where on the strength of a procedural lapse, the defaulting party has gained advantage of law for a period of almost 94 months, then such procedural lapse is required to be viewed seriously. Okay, the fact remains another thing. If an RP has not filed report, then it is the duty of the adjudicating authority to ensure that the RP files his report or else replace the RP. So herein the court said that with regard to RP's failure, this particular case, NCLT looked into, segregated the case into two parts. One was pertaining to not filing of the RP's report under Section 99. And another part was the lapse on the part of the guarantor to serve notice on RP to file the claim, to file the report under Section 99. So NCLAT held that if in the event that in the event that RP does not file a report, then NCLT can definitely change the RP and either ensure that he files the report or he can change the RP. But in this particular case, the personal guarantor got the advantage of interim moratorium for 15 months. Did not allow Bank of Baroda to enforce its guarantee, initiate proceedings under Section 95 because interim moratorium prevailed. So they were sitting pretty. After 15 months, when the matter came up, there was obviously reason for adjudicating authority to take it seriously and cancel the entire proceedings. There was nothing wrong. So when on the strength of a procedural lapse, the defaulting party has gained advantage in law, then such procedural lapse is required to be viewed more seriously. Had this been for 2 months or 3 months, this was different. But when it comes to 15 months, then the matter is different. So the NCLT was absolutely right in cancelling the entire 94th petition. So we move to the last matter. We arrive at the last part of this presentation. We are going to section 95, which is application by creditor to initiate insolvency resolution process. We go to topic 48, if I'm not wrong. Yeah. This is a case of Neeta Saha versus Asset Care and Reconstruction Enterprises Limited. This actually comprises of 3 cases, that is case number 61, 649, and 399 of 2025. But however, all being, similar cases, Neeta Saha matter was taken into account. Here, what happened was the CIRP against the corporate debtor was instituted by home buyers on 28/2/2020. The loan recall notice was sent on 23/3/2020, was issued to financial creditors. And the RP had this, in the CIRP process, the financial creditor had filed claim. The majority claim was disallowed by RP, and against which the financial creditor had moved an application before the NCLT. But at the same time, on 14/3/22, they invoked personal guarantee and claimed 189 crores. And so the question arose as to when there are 3 questions. First was, there was a Section 14 moratorium. So how could 95 be moved? Because Section 14 moratorium is there, so how could 99 be moved? Second was, the demand notice was issued, the loan recall notice was issued on 23/3/20, which was during COVID-19 period. So there also, how could personal guarantee 95 petition be instituted? The third question was RP had raised, had disallowed the loan, disallowed the claim. More than 50% of the claim was disallowed. So the matter went to the guarantors went to NCLAT with the case. So with this, I stop the screen share and I take you to the slide I prepared for you. Now, NCLAT said that Section 10A prohibits filing of application under 7 and 9, 7, 9, and 10 of IBC. And that Section 10A does not in any manner bar proceedings under personal guarantee, which comes under Part 3 of IBC. You will recall that the rules and regulations pertaining to personal insolvency, personal guarantors came out quite recently. It was not there during COVID-19 period. And if you look at Section 10A, it talks about Section 9, 7, 9, and 10. Nothing else. So the plea that 95 cannot be instituted was wrong. The moratorium under Section 14 does not preclude financial creditors to initiate action against 95, against the personal guarantors. Initiate action under Section 95 against personal guarantors. And in the present case, the guarantee was invoked on 14/3/22. So loan recall notice and guarantee invocation are two separate issues, which we have NCLT has held that it is the time when the guarantee is invoked, that is the time when the clock starts ticking. Now, the question of RP disallowing and the matter being the claim of financial creditor being allowed. So the personal guarantors, they had given figures of 30 rupees or rupees 10 crore, whatever. But the fact remained that the due was more than 1 crore. And NCLT being a having summary jurisdiction, they are not required to determine the exactness of the claim or the quantum of the claim. All they are to see whether the claim is more than 1 crore. That is the threshold limit. So there was no ground made out to interfere with the admission of Section 95 application against the appellants. So this is an interesting case. In this, three different things are being discussed. 10A, Section 14, and RP disallowing a part of the claim which is unchallenged. So it's a good read. I would request the viewers to go through the case on the website. With this, we move to the conclusion of this video, and I take you to the concluding part.
Viewers, we have come to the close of, or rather the end of this presentation, which is the last one for the year 2025. I wish you all a very, very Merry Christmas and a very happy and prosperous 2026. Thank you. Bye for now.